Dear participants, a very warm welcome to this lunch webinar. I'm Professor Pascal Pichonnat from the University of Fribourg in Switzerland, and as president of the European Law Institute, it is my great pleasure and privilege to welcome you all to this webinar. In February 2024, ELI membership has approved the so-called ELI Charter on Fundamental Constitutional Principles of a European Democracy. This is such an important project and endeavor to set out the fundamental constitutional principles for European democracy. We at ELI think that this project is timely and will become of great importance as a kind of milestone, given also the current and ever-changing political situation in Europe and around. For those of you who attended already the previous webinars on the topic, you know that the ELI decided to organize a series of webinars to discuss the various parts of such ELI Charter of Fundamental Constitutional Principles. As the project consists of 7 parts, we decided to organize 7 webinars on each single part. The first webinar on liberal democracy, the second on the rule of law, took place in March. The third was on April 24. All the recordings are now available on ELI website. Today's webinar will deal with dignity and equality, focuses on Principle 24, human dignity, Principle 25, equality before the law, and Principle 26 on non-discrimination. As the ELI has done with other projects, each part of the final outcome is broken into principles, and each principle is accompanied by a succinct commentary on its intended meaning and scope. The reporters have also provided an indicative list of references to legal sources. The 2 reporters, Professor Elise Muir and Professor Takis Tridimas, have achieved an incredible work under the chairmanship of Sir Francis Jacobs, first president of the European Law Institute, and Sir Geoffrey Jowell. This project has been presented and discussed several times by the scientific director, Professor Christiane Wenderhorst, and by the executive committee, as well as by the ELI Council. Moreover, the project, or parts of it, have been presented at several occasions at the ELI annual conference, but also at high-level conferences on constitutional law. The final outcome is therefore the result of the individual work of the co-reporters, of course, but benefited a lot from collective thinking and interactions. As always, you will be able to ask your questions thanks to the Q&A function, and we will answer those questions in the Q&A section after the first round of presentations. Today, we have the pleasure to have one of the co-reporters, Professor Elise Muir, with us. She will introduce the various aspects of the Charter, and in particular, Part 5. Elise Muir is Professor of EU Law at KU Leuven. She has a particular interest in EU constitutional and fundamental rights, as is illustrated by her 2 monographs in the field, published in 2012 by Kluwer and 2018 by OUP. She's the principal investigator of the so-called Reshuffle project, European Research Council, which deals with the transformation of the institutional landscape for the protection of fundamental rights in Europe. She has also recently published a handbook called Introduction to the EU Legal Order, published by Cambridge University Press in 2023. So, Elise, I'm very pleased to hand over to you and for this initial presentation. Thank you.
Thank you so much, dear President, Professor Pichonnat. It's a great pleasure to be here. And as you said, I am only the face of a bigger group, right? Speaking on behalf of a collective that has been working on this project under the chairmanship of Sir Geoffrey Jowell and Francis Jacobs, as well as a co-reporter, Professor Tridimas. And we had, in fact, teams and advisory committees working together. So perhaps by way of introduction, a quick word on the document itself before I dive into the specifics of today's session on Part 5, Dignity and Equality. So the project has resulted in the drafting of a charter on fundamental constitutional principles of a European democracy. This project was in fact initiated within ELAI, and I think that the reasons why it was initiated is very much to seek to respond to ongoing and severe challenges to the fundamentals of liberal democracies in Europe. Seeking to address this call from ELAI, together with the co-reporter, Professor Tridimas, and the chairs, as well as the colleagues, we have tried to deliberate on what we could identify as the essential principles of a European constitutional liberal democracy. So the exercise that we have performed together is primarily an academic exercise, trying to bring together what we felt could be subject to agreements. But it is not only an academic exercise, because we have been deliberating with teams and advisory committees, but also consulting very broadly, thanks to ELAI in particular, disseminating the draft version of the charter for several months, in fact, before it came to be voted by the different instances of the European Law Institute. So it's an academic exercise, a deliberative exercise. And the outcome is indeed what you see, a charter with an introductory memorandum, 36 principles organized in 7 parts, as I will explain. But perhaps before showing you what it looks like, one final word on the sources that we've been using. So how do you actually extract common principles for European liberal constitutional democracy? Well, we used obvious sources, I would say, so the work of the Council of Europe, also the work of the European Union, be it the Charter or the Convention, recommendations, legislation sometimes, but also case law from highest courts. We, of course, also looked at national legal systems, the constitutions, the case law of the highest courts, primarily in Europe, but also drawing inspiration from a number of other legal systems as broadly as possible, in fact, and that was also what we thought through the consultation process organized by ELAI. So a range of official sources, but also a range of academic sources. That is, we also, of course, looked at academic literature on constitutionalism, liberal democracies, and so on and so forth. So as the president said a few minutes ago, in the charter, you will see principles, and below each principle, a commentary, which is in fact a synthesis of the various sources that we have used to draw inspiration from. It's non-exhaustive, as has been said, but it is meant to give an indication of where things stood in your research and how we could reach an agreement together. Now, showing you perhaps on the screen, here we go. This is the structure of the charter. You should be able to see it now, I hope. The ELAI's Charter of Fundamental Constitutional Principles of a European Democracy. It is therefore structured in 7 parts. As you can see, one on liberal democracy, that's where we wanted to start with. The rule of law, judicial independence, check and balances accountability, dignity and equality, which is what we will discuss more in detail today, protection of fundamental rights, and constitutional integrity. Now, what may strike you is that these various headings are very closely related, interrelated. So there is a degree of overlap, which we acknowledge. We also acknowledge that this is not exhaustive. We could not cover more. We made choices to prioritize. And for example, if one looks at the section on part 6, protection of fundamental rights, it is very far from exhaustive. We selected a few fundamental rights, as will be discussed in a future seminar. So we've been selective, and in particular, we've decided to have a specific part on dignity and equality. As I engage through these slides, perhaps one sort of disclaimer, which I don't think is particularly controversial when discussing part 5, but perhaps worth keeping in mind if you scan through the entire charter. We have thought to find a balance between the prescriptive dimension of the project and the descriptive dimension of the project. The idea is essentially to sort of consolidate existing developments, right? To anchor the fundamentals of European democracy in a charter. But we soon realized that we could not be only descriptive, that there would have been a prescriptive dimension to our work. We acknowledge it. We thought there was no alternative. So we always try to be as reasonable and nuanced as possible to combine and to find a balance between uniformity and diversity in Europe. But certainly to acknowledge that there is, to some extent, a prescriptive dimension to our work. For example, if you look at the fundamental rights in the area of automated decision-making, or environmental protection, this is going a bit beyond standard constitutional texts, we acknowledge, but we felt it had to be part of our mission to try to offer some solutions and perhaps guidance for future developments. So now delving into part 5, which, as I said earlier, has been singled out as deserving a part in itself in this charter. It is composed of 3 principles: dignity, human dignity, equality before the law, and non-discrimination. And so I just propose to briefly take them one by one. We start in terms of individual rights with human dignity. We felt, and you can see this from the wording we've chosen, so human dignity is inviolable. It forms the basis of the fundamental rights of the individual and must be respected and protected. So we felt that human dignity came first. This is, I think, closely related to the history of the European continent in a post-World War context, a reaction to the atrocities that took place on our continent. It's a right, the right to human dignity, that is very forceful in the law of the ECHR, of the Council of Europe, but of the European Convention for Human Rights. It is not mentioned as such, but is very present in the case law of the Court for Human Rights. For example, it is asserted that it's a basis for the right to life or the prohibition of inhuman and degrading treatment. It's also very present in European Union law. It is mentioned in the Charter of the European Union, but it's also very present in other international instruments, such as the Universal Declaration of Human Rights, the Covenant on Civil and Political Rights, as well as the other international covenant on economic, social, and cultural rights. So it's an omnipresent right, and we felt it was the right approach to put it forward first. It's also, of course, extremely present in various constitutions across the European continent as well as elsewhere, for example, the US. Now, we acknowledge that in a specific factual legal context, the interpretation or the application of the right to human dignity may lead to some differences in different national settings. But we felt it was important, nevertheless, despite some possible nuances, to assert and agree on the fact that certain things would not be acceptable in Europe. For example, torture or degrading treatment or the legalization of marital rape would seem unacceptable in accordance with European standards. Now, the second principle in part 5 is the principle of equality before the law. Everyone is equal before the law. We also felt that this was a right and a principle to be asserted at the forefront, to be put forward early in the Charter before the fundamental rights that follow in the next section. Why? Because it seems to us that this is central to the rule of law. The idea that everyone should be equal before the law. Now, you will see that there is another principle following soon after, the principle of non-discrimination. We acknowledge that the principles are very closely interrelated. But here the idea is to focus on the more formal dimension of equality, the idea that comparable situations should be treated in the same way. And conversely, different situations should not be treated in the same way. So there's positive and negative dimension of equality. Again, this is a principle that is mentioned in various sources at European level. The Convention for Human Rights in Protocol 14 says all the rights in in Article 14, all the rights in the Convention should apply equally to all. In the Charter, Article 20 of the Charter of Fundamental Rights of the EU, but also in UN instruments and in various constitutions. Now, again, we acknowledge that the idea of formal equality may be very closely related to the idea of substantive equality. The need to go a little bit more beyond formal equality to be able to actually promote full participation in society. So this is something that is closely related to the next principle, the principle of non-discrimination, which we wanted still to have as a stand-alone principle next to equality. The principle of non-discrimination, and as you can see here on several, covering several grounds, a prohibition of discrimination on grounds of sex, race, color, ethnic or social origin, genetic features, language, religion or belief, political or any other opinion, membership of a national minority, property, birth, disability, age, or sexual orientation. And it's a non-exhaustive list, right? We didn't mean to close the conversation. But the idea is that in many legal systems in Europe, as well as at EU level, there is a willingness, a desire to go beyond formal equality, to prohibit not only direct, but also indirect discrimination, to allow the states to develop mechanisms of, for example, positive action. And again, this principle is mentioned in several instruments, and even if not in all instruments. So, for example, the protocol on non-discrimination of the ECHR has not been ratified by all member states. Nevertheless, we felt it was so closely related to the principle of equality, which is accepted across Europe, that it deserved a fully fledged principle. So in order to leave enough time for conversation, I will stop here because I've slightly exceeded my time and apologize. I look forward to further exchanges. Thank you very much for bearing with me.
Thank you very much, Elise Muir, for this overview presentation. And also, I think it was really interesting to see the internal relations you had in mind when drafting these three principles that are indeed very broad. And so we need now to dig a bit further with our exceptional panelists today. And we will begin with human dignity, with the Director General of Democracy and Human Dignity, DG2, Maria Ruotanen. I'm very pleased that she was able to join us today. She has over 30 years of professional experience in several intergovernmental sectors of the Council of Europe, involving cooperation, monitoring, and standard setting, as well as in the Parliamentary Assembly. And as I said, she's currently the Director General of Democracy and Human Dignity. Her areas of responsibility include children's rights, trafficking in human beings, gender equality, violence against women, addressing intolerance and discrimination, freedom of expression, media, civil society, youth participation. I wanted to give all the potential fundamental rights in a way that you cover through, of course, your analysis and your being the Director General, and of course also your understanding of the interrelation between all this to get to human dignity. So, of course, it's a difficult task now to bring some further ideas on this aspect that I'm really thrilled to hand over to you, Maria Ruotanen. Thank you for being with us.
Thank you very much, and good afternoon to everybody. First of all, congratulations for having put together such a nicely interlinked principles in your study. I think it's really important to see, because we at the Council of Europe that I'm working for, we are intergovernmental regional organization composed of 46 member states, and we are very much looking at these different components that you have in a package. Because let's say in terms of equality and human dignity, you have to have functioning democracy and so on and so forth. So I think it's very, very much in line what we are doing here at the Council of Europe. So Council of Europe, as I said, it's an intergovernmental organization. It's really dedicated, let's say its core values are promoting democracy, human rights, and the rule of law across the continent. And over the 75 years, because we are celebrating this year the 75 years of the Council of Europe, we have developed a very dynamic approach to uphold human dignity, placing at the very center of all its efforts in protecting human rights. So I think what already the previous speaker mentioned, made references to the European Convention of Human Rights. There is no provision that is specifically referring to human dignity. And the lack of that has allowed the court to interpret the convention as providing a protection of human dignity with respect to each fundamental rights. As early as in 1995, there was a case against Sweden concerning marital rape, and it already there refers to human dignity as one of the fundamental freedoms. So we can say that human dignity is really a central part of the court's case law, namely on Article 2, Article 3, 4, and also 8. And it really underpins the commitment to protect human rights and highlights the centrality of it for the human beings. Other instruments that contain this human rights dignity, of course, are Additional Protocol 13 on abolition of death penalty, and also the Biomedicine Oviedo Convention, and 3 specific conventions that I would like to now discuss with you further. And these 3 areas are conventions where we at the Council of Europe are working very much to promote and protect the dignity, where it's really at the center. And these are violence against women, sexual exploitation of children, and trafficking human beings. So these areas are, of course, very much interconnected as well. And they are areas where we have a specific convention at the Council of Europe to protect them, always putting the victim at the center of these conventions, therefore being human dignity centered. So they are not just criminal conventions, but they really have the victim at the center to, first of all, to prevent and protect these crimes from happening. So I would start with the violence against women. And as you know, I would say Council of Europe is at the forefront of combating violence against women and recognizing that as one of the most grave violations of human rights, and also a breach of a human dignity as regards women and girls. And it is also, when we talk about equality, a huge barrier to gender equality. Many aspects of violence against women actually are the chilling effects why women would not want to become, for example, elected officials, because they fear and they see what is happening in terms of violence against a woman on political area. So we are very proud of our flagship legal instrument that we are now going to celebrate this year, the 10 years of its entry into force, the Istanbul Convention, which is Convention on Preventing and Combating Violence Against Women and Domestic Violence. And UN, for example, has referred to it as the gold standard. It's a very demanding, I would say, convention to ratify, because it is almost like a shopping list of number of things that need to be done to protect victims, to prevent, of course, violence, and also to prosecute perpetrators. And what we also have in this convention, like in the 2 others that I will present, is also the coordinated policies. So we call them the 4P conventions, and the coordinated policies is really very important, challenging, but at the same time, the most important also in making sure that the different parts of the states that have ratified work together, because it cannot be just, for example, one ministry that addresses this. So although we are celebrating only 10 years of that Istanbul Convention, and considering the fact that it's a very challenging convention, we have today 39 states that are party to the convention, and that includes, by the way, European Union that has ratified the convention recently. So I think this is important to mention one of the most recent dignity conventions that we have here at the Council of Europe. And I would like to maybe highlight 3 areas of this convention that are very important to all its provisions that are also interlinked. And the first aspect is dignity, because the Istanbul Convention criminalizes the very behavior in intimate relationship and beyond. And not too long ago, also these aspects were not considered as something that the states are responsible, but they were private matters. And now, for example, thanks to the Istanbul Convention, intimate partner violence, and as we mentioned before, rape within marriage, is also something that is considered as a violation of human dignity. Also, what I would like to underline is the autonomy, because the convention is really trying to protect women in a way that they can leave an abusive relationship and be autonomous and be able to build their own lives. And these are, of course, protection measures that need to be taken into place, not only economic, but also banning orders, eviction orders to allow the woman to leave safely after she has left the abusive relationship. And the third aspect I would like to mention is respect, because it's an aspect that underpins all of these provisions of the Istanbul Convention that require a gender-sensitive approach from all statutory agencies. That includes law enforcement, criminal justice sector, and also family law professionals when they deal with aspects of, for example, child custody or visitation decisions after abuse. So respect of women's dignity is at the very center of these deliberations of the Istanbul Convention. And the second conventions I would like to highlight here in terms of human dignity is related to children, and it concerns the Council of Europe Convention on Protecting Children Against Sexual Exploitation and Sexual Abuse. It is slightly older convention. It entered into force 2010, and it has today 46 member states that has ratified it. So it's a very widely ratified convention. And it also has 2 non-member states. That means the Russian Federation that ratified it before they were expelled from the Council of Europe, and also Tunisia. Actually, all these conventions that I'm mentioning to you, they are open conventions in a way that any party in the world can accede to them. So this particular convention that we call Lanzarote Convention covers all possible kinds of sexual offenses against children, whether it's a sexual abuse of child, exploitation of children through prostitution, grooming and corruption of children through exposure to sexual content and activities that are and offenses related to child abuse material. So these are, of course, at the very core of our concept of human dignity, and they are even more serious because what we have through the monitoring of this Lanzarote Convention been able to prove that much of these abuses happen in the close circle of trust, whether it's family or other circles where the child is surrounded by persons that actually should be there to protect him or her. So by ratifying this Lanzarote instrument, the member states are really dedicated to ensuring that every child enjoys their right to live life free from harm and exploitation, to live in dignity. So today we are, of course, considering, I mean, it's not that old convention, but we are now seeing, of course, the impacts of the artificial intelligence and also the social media, and how these are very, very prominent when you talk about this protection of children. And we are now seeing how we can address this through different standards that we are preparing to complement the Lanzarote Convention. And the last area I would like to mention is trafficking human beings. And this is the oldest of these human dignity conventions that I have referred to. It's also one of those that really put human trafficking at the center, looking at it as a modern form of slavery, and putting the victim, protecting first and foremost the victim, not seeing it as a crime, only criminal convention like it many other organizations have. So this is, I think, important because it's a focus on the trafficking that, as I said, is building the safeguards for the victim to make sure that whenever he or she is in front of the law, that person is seen first and foremost as a victim. And this is now, this convention is also ratified by all the Council of Europe member states and also by Israel and Belarus. And many of these conventions actually, well, 2 of them, that means the Lanzarote is monitored by the state parties, but the two other, the trafficking and Istanbul, they are monitored by two instances. First one being the group of independent experts. That means that there is a group of experts that are elected, and they come from a very, very heterogeneous background, and they do country visits to check the situation against the state reports that we do receive. So I think this is bringing us really a wealth of information on which we can build on and where we can see what are the most pressing challenges that member states are facing in implementing these conventions. And as a result, they are proposing recommendations or guidance notes to address, to help member states further to address them in their fight against these violations. And I think in conclusions, I would like to say that I provided these three human dignity examples, but they are all very, very close to linked, of course, with equality and access to justice by the victims of all these three, whether it's violence against woman or child or a trafficked person, is of course a major issue. And we are trying to also see how to empower the victims so that they can be supported and they can be seeking justice on an equal ground and be able to receive it. We had a year ago, almost exactly a year ago, meeting of the summit of the heads of states and government in Reykjavik, and they adopted different declarations where they also put the dignity and equality as principal components of foundations of a modern European society. So that is something that we will be continuing to do, and as I said before, focusing on the 4 Ps of all these conventions: prevention, protection, prosecution, and supporting coordinated policies. So I do stop here because I do realize that I went maybe over the time allocated, but I'm ready for questions, of course, after.
Thank you very much, Director General Ruotanen, for this this analysis and presentation that also underlines one important aspect. I think you mentioned monitoring and implementation, which is of course fundamental, and these European Law Institute Charter is of course soft law, and it needs to get, of course, on the one hand, it's a nice support to engage in dialogue and discussion about all this, but at the same time, of course, the idea is also that this is taken up by member states. Of course, human dignity is so central. This has been taken up by most of the states, including in ratifying these conventions you just mentioned, that are so central and fundamental for the life in society. But I think we will be able to come back on that later on in the Q&A. But thank you very much, really. We will continue now with the principle 25, dealing with equality. And I have the pleasure to greet Patrick Charlier. He's a lawyer at Louvain-la-Neuve at UCL. Interesting, today we have someone from KU Leuven and from the Flemish part, and someone from Louvain-la-Neuve, the French part. He worked at the Ligue des Droits Humains, first as legal advisor and then as director until 2001. And since joining UNIA, an independent public institution that fights discrimination and promotes equality in Belgium, in 2001, he has held various positions in the racism department at the Migration Observatory before becoming coordinator of the discrimination department and finally director. Patrick Charlier has been chair of Equinet, also the European Network of Equality Bodies, since October 23, and is an alternate member of the Central Prison Supervisory Board. So who better than him to present us some reflections on Principle 25 and the issue or idea of equality before the law. You have the floor. Thank you.
Yes, thank you. You can hear me well? Yes, thank you. And I will speak here in my capacity of chair of Equinet, and I thank you for this invitation and the opportunity to share a little bit of experience of equality bodies. And of course, I will speak about the principle 25, but as already said, it's linked with the 26, equality and non-discrimination. There is a strong link between those two principles. Perhaps just speaking a little bit about Equinet. Equinet is a network of national equality bodies. We have 48 members from 38 different countries in Europe and then far beyond the EU country. Even if equality body has been created thanks to the anti-discrimination directive, and especially the racial directive and different genders equality and non-discrimination directives. And we are independent public institution, public services, and there can be several equality body in one country. So that's why there are more equality than country. And for example, in Belgium, there are 3 equality bodies now. This body plays a crucial role ensuring that laws and policies are implemented effectively to prevent discrimination and promote equal treatment for everybody, regardless. And you know that there are the protected ground from EU: gender, race, ethnicity, disability, age, sexual orientation, religion, belief, that the 6th one, but many of the equality body can address also other forms of discrimination. And when we see the list in Article 26 of the Euro principle of the Charter, we, for example, in Belgium, but there are many countries that can address also other grounds like social position, health, genetic feature, and so on. There is a strong diversity among national equality bodies in terms of size. There are very small equality bodies with 5 of them people are working, and some of them, there are more than hundreds personnel working in this equality body. There are differences in the mandates. There are multi-grounds mandates, equality body that work on all grounds, but we have also single grounds bodies, and especially somebody are focused on gender or disability. That's what we see most of the time in several countries. And we have also what we call multi-mandate body. That's body that are not only competent for equality body, but they are also acting as national human rights institution, national prevention mechanism for the OPCAT, or other competence like ombuds function, and so on. There is a very strong diversity between equality bodies, but we hope that in the future there will be a leveling up because we are waiting and expecting that on the 7th of May, the last stone will be put with the adoption for the 2 EU directive on standard for equality body that are giving more importance on independence, resources, mandate, and power for all equality body. It's a long journey, it's a long process, and we hope and we are pretty sure that we can enjoy a new form of frame for equality bodies, and it was a long work with the Commission, the Council, and the Parliament. Speaking about formal equality before the law is understood by the explanatory comment from the ELI Charter as a formal equality. The law must be applied equally to everyone. Formal equality is, of course, a vital starting point for democratic states where all citizens enjoy their human rights on an equal basis. Nevertheless, as recognized in the Charter, formal equality on its own is not sufficient to ensure the enjoyment of their rights on equal basis for all individuals. Further, if stating in the law that we are all equal would be enough, we would not be talking about violation of the principle of equality at all. In practice, and that's important for us, pre-existing inequalities stemming from systemic and structural discrimination as well as intersecting grounds of discrimination, hinder the effectiveness of this principle for marginalized groups. Treating everyone as equal in the face of a long-term disadvantages actually results of the perpetuation of the unequal status quo. It is therefore necessary for legislation and policy measures to uncover and take these structural and pre-existing inequalities into account when designing equality measures. Furthermore, by adopting an intersectional perspective, particular attention and resources must be allocated to the most vulnerable within all marginalized groups. In this sense, the full and effective equality before the law requires not only negative, but also positive actions. Therefore, formal equality needs to be complemented and directed to the achievement of substantive equality, focusing on the equality of outcome for all individuals. Apart from this, equality before the law can only be effectively ensured if equality legislation is implemented and enforced. This requires the respect for the rule of law and an effective and equal access to justice for everyone, and the availability of sanctions and remedies in case of violation of this principle. In that sense, equality bodies play a vital role in rendering the principle of equality before the law effective in practice. It is our responsibility to ensure equal access to enjoyment and enforcement of rights, while at the same time we are working towards substantive equality through addressing and advocating for the elimination of structural inequalities. And I would like to underline that structural inequalities are often invisible, and that's why it's important to address this question. It's sometimes impossible to detect structural inequality through individual cases, and that's why we try to focus also on structural or systemic discrimination patterns. Our members are legal practitioners. They use the law. They are independent, free of cost, institutional mechanisms that support rights holders and uphold the principle of equality in a 360-degree way. In that sense, we think that we are part of the democracy, and I think there are no equality body in country which were not seen as democracy, and that's the way that we are acting every day. We are dealing with individual cases, and we see each of us as at the services of the population and to people who are facing discrimination. And that's important. We are not advocating for ourselves, but we are advocating for people who are facing discrimination in their life, in work, in education, in housing, in health, and so on. And that's the way for us to enable access to justice for those people and for everyone. We are supporting victims. This includes, for example, raising awareness to inform right holders about their rights. There are some survey that has been done by the Fundamental Rights Agency that show that the awareness of the prohibition of discrimination is pretty low in the population, and that's on our role to make known that there are non-discrimination and equality principles that must be addressed for everybody. Some equality body can bring case in front of courts in their own name, while other of us receive and investigate complaints of discrimination and issue binding or non-binding decision in individual cases. For Equinet, a strong institutional architecture is indispensable for an effective drive towards equality, encompassing formal as well substantive equality. As we have seen, equality bodies are a crucial part of this architecture, and strengthening them will directly contribute for more equal society. Therefore, we welcome the successful negotiation and imminent adoption of those two directives I already speak about on standards for equality body to ensure stronger institutions in the service of all victims of discrimination, offering guarantees on independence, resources, mandates, and powers. I thank you for your attention.
Thank you very much, Patrick Charlier, for this presentation, also for underlining the importance of these equality bodies in the education to fundamental rights and therefore also to the understanding of equality, which is central, and for addressing these issues that from the 7th of May now, there will be this common ground in equality bodies that are also very important to ensure, including in this aspect of the alternative dispute resolutions, if I may, because that's also central. Before trying to sanction, one needs really to try to find positive answers to some of the difficulties. So thank you very much. I'm sure we will come back to that. And let me now turn to our last but not least of our speakers today, Katarzyna Sekoczka-Korlowska. She holds a PhD in law and is currently assistant professor at the Institute of Law Studies of the Polish Academy of Sciences. She's also the director of the Poznan Human Rights Center of the Institute of Law Studies of the Polish Academy of Sciences, and a member of the Interdisciplinary Center for Cultural Gender and Identity Studies of the Adam Mickiewicz University. And she's also an expert of the European Commission and Council of Europe. Her field of research is international human rights law with a focus on gender issues. And that's why we thought it would be very appropriate for her to reflect upon Principle 26 on the non-discrimination. And so I'm happy to hand over to you, Kasia. Thank you.
Thank you very much. Good afternoon to everyone. I'm very happy and honored to be here with you. And first of all, I would like to congratulate, because the whole project and the final product is extremely ambitious one. So I really feel that discussing the very small piece of it does not give the credit to the whole achievement. But of course, I will be very happy to share my thoughts about Article 26. And of course, we have to know, and it was already acknowledged, that this is strictly related to Article 25. So we should read them together, that as both provisions about formal and substantive equality. So when I was preparing to this meeting, I was wondering about this aspect that was mentioned by Elise. Is it more descriptive task or more perspective dimension of your achievement? I mean, was your intention rather to reflect the legal reality, or also to push forward some changes or maybe some ideas that you feel that it would be desired to have in national legislations? So of course, I think that the wording of the Principle 26 is great because it's simple, and of course it mirrors also the EU Charter of Fundamental Rights provisions. So usually in law we feel that less is better. So I have feeling that all 3 articles that we discussed today are really well done, because each word counts, and sometimes it's better to have words shortened than to put as much as you want in this kind of product. So I know that your charter is not a charter of wishing list, but if I could add something and put 2 points to discussion, perhaps we could have some thoughts on that. So I was thinking about two things that also bother me as researchers. So these are 2 points that I would like to raise. First is so-called, let's call it gender trouble. So do we need gender in provisions like that? Because here now in Principle 26, that of course offers this open non-discrimination clause, that it's open for each grant on non-discrimination. We have only sex. And I must say that I'm still wondering, do we really need gender in this kind of provision or not? Because of course now it's almost it's obvious that sex, it's not only about biological aspects, but we also talk about gender. I mean, like sociological and cultural aspects of being or being men or women. So I have feeling that this is rather this direction of modern anti-discrimination clauses, that perhaps it shouldn't be only about sex, but also about gender. And here in the principles, we have sex, and we have sexual orientation, but what about gender? So what about all this situation when it's not about just feeling biological sex, but also about all these cultural aspects, about feeling binary or non-binary, about being transgender. So I must say that as a person who deals mostly with discrimination against women, I still have this feeling that gender makes us quite a lot of troubles in law. I mean, the notion itself and also its political implications and all this gender identity, the gender ideology battles and so on and so forth. But still, I'm thinking that maybe if we, let's say, promote the modern anti-discrimination principle, I feel that gender should be there. And the second point I would like to raise is the issue of, let's say, promoting proactive approach. What I really like in your comment is that you are really strict, that this is that the principle is about achieving substantive equality. And as we know, of course, to achieve substantive equality, we need very various measures, including positive action measures, or let's call it affirmative measures, but also, for instance, reasonable accommodation for persons with disabilities, but also to some others. So I have feeling that now in modern anti-discrimination law, we need more open and proactive approach to positive action. Because this is this kind of paradox in EU law, that to some extent the EU promotes positive action, but honestly speaking, the wording or its documents are not very encouraging to member states to introduce this kind of measures. And honestly speaking, this wording is also mirrored in your commentary. I mean, like the principle of non-discrimination does not prevent states to use affirmative action, or affirmative action is not per se prohibited. And of course, it's true, but I have feeling that we need more proactive approach. And for instance, in preamble to Protocol 12 to the European Convention on Human Rights, we have this some statement on measures that could be undertaken to achieve equality. It's again about not prohibiting to use them. So as we know, we don't have obligation to use affirmative action measures under European Convention or under the EU law. But I'm thinking that maybe we can find some way to speak more openly in legal standards in a way to encourage countries to use these measures, and not only showing them that, okay, if you really want to use them, you can do it. So these are some of my thoughts about substantive equality and Principle 26, but of course it's just some point for academic discussion and not the criticism on its wording, which I said it's really it's put in a very, very correct and elegant way. Thank you very much.
Thank you very much for these various points. I think very well taken, and I'm sure I will have to hand over to Professor Muir to react or maybe explain also the process that, for instance, linked to keep the word sex instead of gender, or one and not the other, or not both, for instance. And also you put the finger really on some interesting wordings where one could think, oh, here we could have done, you know, be more proactive, including, by the way, I think in the principle itself, principle 26 itself, where it's only meant that shall be prohibited, and there's no direct, in that provision, no direct link to the positive measures. But of course, if you look at the comment, but also at the general framework, one can also potentially understand the decisions that have been taken. But I would be very happy to listen also to reactions by Professor Muir. Thank you very much there for all these aspects and these comments. I would like now to remind everyone that we have about half an hour for Q&A, for questions and different answers. I will try to focus on the various people here. And so maybe as a first reaction, yes, please, Elise Muir, I hand over to you if you want to comment on one or the other presentations, and we will continue with a number of questions.
Thank you so much, Professor Pichonas, and in fact, thank you to also the members of this panel. Well, there is plenty of food for thoughts in your reactions. Perhaps I should first react to the contributions and of the panel members. I see there are also some questions, but I will let you decide, Mr. Chairman, how you wish me to proceed. So, well, first of all, perhaps a quick come back on what President Pichonas commented during two contributions in terms of who are the addressees of this charter. It is soft law, as you said, but the idea is to allow all kinds of actors, political, elected or non-elected, I mean, members of the political activities at state and European level, practitioners, but also perhaps civil society organizations. And I think that's really important for these ideas of human dignity, equality, to use this to consolidate their approaches if they want to. And I was also pleased to hear, in particular from Director Rotan and Mr. Charlier, that there was an obvious link between democracy, dignity, and equality, which is really because the Charter is about the idea of a constitutional liberal democracy. That's why we went to pick up these particular rights and to single them out. Moving on to perhaps what Professor Sienkowska-Koslowska was saying, I think you're right. There is a tension which we acknowledge between the descriptive nature of the project and the prescriptive nature of the project. And I think these specific articles or principles, dignity, equality, and non-discrimination are overall descriptive. I think you're right. So we build on established consensus largely, possibly bridging a bit beyond, stressing the importance of indirect discrimination, asserting non-discrimination, even if not all member states of the Council of Europe have ratified the protocol on non-discrimination. So we go a bit beyond. We didn't go as far as to discuss gender or intersectionality, which Mr. Charlier also mentioned, or to push or call for positive action. You're right, you identify, I think, limitations of our project. I think it's related to the nature of the project, no? Which indeed tries to balance descriptive and prescriptives in a very careful way, because the idea is to build consensus on a European set of principles. And as I'm sure you know better than I do, gender is very controversial in certain parts of Europe. it is debated in the European Parliaments itself of the European Union and in other fora. So these are things, you're right, this is not a personal reflection of our views, it is an attempt at building consensus, and that is why we've decided to be light touch on this concept, while reasserting not only formal equality, but also the need to protect substantive equality. I also wanted to pick up on a point made by Director Ruotanen on the importance of access to justice. It's all beautiful to assert dignity through a set of conventions at the Council of Europe, through various forms of legal action at EU, Council of Europe, and Member States level. But we need access to justice to enforce these rights. And this is something we touch upon in the Charter. We have a principle on the need to have a right to a fair trial and effective judicial protection, Principle 10. We have an entire section devoted to judicial independence, which is a key element to ensure effective judicial protection. So I thought there are also complementarities there with other parts of the Charter. And this idea of access to justice, I think, is also related to what Mr. Charlier was describing in terms of the importance of equality bodies and others, NGOs, civil society organizations, lawyers, to support the implementation of the policies, to support victims. You also say, President Pichonas, the importance of alternative dispute resolution mechanisms. So these are things that the Charter itself does not deal with, because it is not its purpose, I think, and its nature is to focus on key common features of a liberal democracy, but this is not to ignore the importance of these other components. What I would just stress is that we have in the Charter a principle on the duty of a set of actors to uphold and respect constitutional values enshrined in the Charter. So this is a small hint at more positive measures to be developed in Europe to enhance the values in the Charter. And I would perhaps just conclude, well, at least this element of the discussion, by stressing that throughout the Charter, we have also tried to pay attention to the duties not only of state and public authorities, but also of private parties, which in the area of non-discrimination, but also human dignity, matters, right? Individuals should also behave carefully and pay attention to these principles. So this is, for example, something that you find in principle number 28 on the application to private parties of the obligation to respect fundamental rights. So here again, we've tried to go perhaps a bit beyond the standard narrative in strictly speaking in constitutional text. But I'm happy to hear more from exchanges and maybe take more questions if you'd like to.
Sure. Thank you very much, Professor Weir. And I think we can go through a couple of these questions. Some are very general in the Q&A, some are more specific. I will begin maybe with a more specific one. And of course, to everyone listening to this podcast, you can, or webinar, sorry, you can continue to ask questions, and we are happy to try to answer those. I wanted to take up on the question regarding the principle of human dignity. The question says it is especially closely related to equality and non-discrimination, which is not surprising because it's under the same subtitle here. But also the question is, how is it with other fundamental rights? And in a way, is it more linked really to equality and non-discrimination than related to other fundamental rights? Because they are of course, addressed here in the Charter? And if so, what can be derived from this insight with regard to the concrete realization of rights? Does it has an impact when one wants to apply other fundamental rights, given the fact that it is maybe linked more closely formally here in the Charter, but more generally maybe also to these two fundamental principles? So I thought maybe I would begin with you, Director Ruotanen, and then maybe others want to add something too.
Yes, thank you very much. I think there are very, very interesting points raised also by Elise Mire a while ago, and also in the chat that I was just looking at. I think, you know, it's obvious that the the human dignity and anti-discrimination, they are tied together. You cannot have, they are more or less the two sides of the same coin. I think you cannot have one without another. And when you talk about equality, there are so many intersectionalities in there that are very closely related now to areas of discrimination. If I may just go to an area that I see very interesting in the questions that were put is about how do European democracies provide for equality and human dignity. I think it's a very, very important question, especially today, because what we are seeing, at least in the Council of Europe, is the backlash that we see on democracies and how we can counter this. And we are very much now trying to see how to enhance the involvement of young people. And I think this is extremely important to make sure that young people are listened to on all matters, not just topics that are definitely just young, but on all the different things. And we are trying to involve, and we actually involving young people when we talk about artificial intelligence, developing standards and so on and so forth. So they do have a say, and much more and more structured than I would say we have been doing before. So we are involving them in the work of, for example, standard setting in intergovernmental committees to ensure that this equality also from the young is really an integral part of our democracies. And also the civil society was mentioned before, and this is something that we of course work with the civil society, but this has become much more structured now. Information that we get from the civil society, for example, when we do monitor the standards of for example, the convention, is really worth a lot. We get very, very valuable information from them because they are often the ones who are really on the ground, closest to the topic. So I think there we also want to structure this much more in our way we approach them and how we work with them. About the terminology and gender that was already mentioned also before, it is true. It's still, I would say there are still quite a lot of questioning around it. We at the Council of Europe, we definitely use the term gender. We talk about the gender equality strategy and so on and so forth. And the Istanbul Convention is also quite clear what does the gender mean in the context of the Istanbul Convention. So I think, but doesn't mean that it wouldn't be clear concept for everybody. And we definitely want to see the word gender also, as I said before, in a very varied way, in looking into sectionalities. And we have a specific recommendation. We don't have a convention that means a legally binding instrument, but the recommendation that is especially focusing on protection and rights of sexual orientation and sexual identity persons. And this is something that dates from 2010, and I think is quite detailed and provides the different categories of areas where discrimination is likely to happen and where we have to make progress. And we are monitoring this as well. It's voluntary basis, of course, because it's not legally binding, but I think it's bringing forward a lot of information that is very, very important when we talk about anti-discrimination, equality, access to justice. And I should also mention about the children's rights, because I think there we have to remember also that they also face issues or challenges related to access to justice. And what I think is important to see here, how we can approach a minor who has been a victim of, well, what we consider human dignity. We are very much trying to help providing them a one-stop place where minors can be heard by different professionals to, in a way, make sure that they don't have to repeat their where they have felt violence several times. So their dignity is also protected from that point of view. And what I'm referring especially here is the Icelandic Barnahuset model, where you are really making a safe space for children so that they can tell their story. So I think maybe there I would stop, because I think others might want to also see their or give their view of this, but I think, you know, you cannot look at the equality separate from anti-discrimination. That is certainly something that I would like to underline.
Thank you very much. Thank you also for these various perspectives. So maybe I would hand over to Professor Katarzyna Kozłowska, because you might want to react on both comments that have been done, and also maybe on this issue of proportionality, which is implied in the first question that was put in the Q&R, how to align rights of individuals and collective interests of society. And of course, these rights tend, because they are so fundamental, tend to be almost absolute. But then you still have a kind of assessment in the margin how to balance these two aspects. So maybe you want to react on that also, but you're free to answer to whatever you want.
Yeah, I have feeling that if I knew the answer for this question that you already asked, I would be a very powerful person, because it's really complex, and I don't have any ready prescription in my head. And honestly speaking, I was still thinking about this issue of putting dignity and equality and non-discrimination in the one chapter. So rather more, let's say, theoretical question about having these three values together, and let's say that having them outside the brackets before the others provisions on fundamental rights. And I must say that I like this construction very much, because of course we can talk about right to equality or right to non-discrimination, but obviously it's not the same right as other rights, like right to life or right to free elections. So I think that these are really like some kind of meta rights, that meta principles that secure our realization of other rights. So that's why I think that it's really good idea to have these principles in somehow separated and put on the same level, let's say, as dignity, because it really demonstrates the role of these principles in securing access to human rights, and of course their linkage to dignity. So these are my observations about this issue that was raised in the question. Thanks.
Thank you very much. Yeah, I'm coming to you, Elise, indeed, Elise Muir, for further issues. I was just thinking that with these three principles, I mean, we are really at the core of fundamental rights linked to the human person, and therefore, of course, it's probably very difficult to find the right, not only balance, but the right approach to not be too just general, to have some level of concretization, but at the same time, these are fundamental principles. And so one cannot go further than a certain level of concretization, because otherwise you would just write books on every of these various aspects. So maybe you could also explain a little bit, how did you manage to keep it both simple, so to say, but also accurate, despite this very central position of these three principles? So, Professor Muir.
Thank you so much for giving me the floor back. Yeah, I really sort of wanted also to follow up, so I'm grateful you've given me the floor back. I would say perhaps 2 points. Maybe first of all, if I may, just I think it's true that we consider dignity, equality, and non-discrimination to really be special. They are sort of horizontal. They have a sort of a meta dimension. In Europe in particular, I think this is just very characteristic of the last 50, 60 years of European developments. Human dignity and equality really have been at the core of what brings us together. That being said, I wouldn't be too exhaustive. I mean, for example, there is a principle 31 in our charter, on social solidarity. which is a very delicate also principle, but it's closely related to dignity. The reason why we decided to have it there is that you cannot have a real democracy if there is not a level of solidarity that allows everyone to participate. And that is also related to human dignity. There must be a possibility to provide minimum education, access to health. Again, it's been a difficult principle to draft because we're looking at a European principle necessary for a constitutional liberal democracy. But we also felt that it goes hand in hand with democracy and equality. I mean, the basics must be there in a socio-economic perspective for people to be able to engage in the functioning of a democracy. So that's it. I just wanted to also make the link with this right, which is a bit outsourced. It is in the next section, but in the commentaries on dignity, we make a link also with this right. And then to come back on your specific question, Pascal, you're right. I mean, this entire charter is an exercise of balancing generality with, I don't know, with relevance. I think to achieve this, it may be imperfect. I'm not saying that this, I'm sure this could be done differently and better. But the way we've done it has just been trying to seek consensus among a group of academics, with a team, with an advisory committee, and then circulating it as you have kindly offered at the European Law Institute, Mr. Pichonaz, through the network and in fact beyond the network, because this has gone to a whole range of organizations outside of LI, to try to fine-tune and to put forward for the first time a text that may be as imperfect as it is, but that seeks to set out what a group considers to be fundamental. I don't have a perfect answer because I don't think there is a perfect answer. I think this is just a process, and it's a process for which institutional support such as that of LI, I think, is key to create a reflection, to steer it, and to allow a dialogue around the reflection. I think this is just a method.
Indeed, thank you very much. And also these series of webinars are also part of this continuing close discussion between various partners and various institutions, and that will probably also help to have cross-fertilization ideas that going from one to the other institution, and that's certainly also one of the purposes. So thank you very much also for indicating this aspect of Article 31 on social solidarity, because that's really related of course, on a more specific or more a kind of different angle, but very related to this topic. I see there's a new question, which is directly asked to Katarzyna Kozłowska on how to assess the current EU case law with regard to positive or affirmative actions, in the sense that maybe there's no leeway anymore for further positive measures in this area, because you mentioned, one has to be or could have been more affirmative on these positive measures to take, and the question, as I see here, is, but is there, at least within the European Union, is there some room for that, especially linked to the binding gender quotas, as was mentioned here, but maybe also to other aspects?
Yeah, thank you very much for this question. So as for the EU case law, as far as I know, we don't have any current one. I mean, like in terms of judgments of the Court of Court of Justice, this is quite old case law with famous Kalanka or Marshall cases, or the other cases. So it's back like 20 years. It was delivered like 20 years ago or more. And as all we know, this case law was not very, let's say, encouraging for the member states to use affirmative action or, let's say, positive measures. But of course, now we have important developments. I mean, of course, the EU directive on a quota for the for the boards, because for the first time in the EU law, we have the provision, the binding provision that oblige states to secure using positive action in their national law. So I think that this is quite big breakthrough, and of course it's only about some small aspect of, but very important aspect of the EU law and operating of the EU law in member states. But I think that it gives good potential to open again the discussion about positive action, especially in employment, and maybe to try to push more a progressive approach among member states towards these measures. Thank you.
Thank you very much. I see another, and maybe that will be our last question for this session. There's a question linked directly to the Treaty of the European Union and Article 2 and 49. And the question is also linked to the requirement for EU membership and possibly to facilitate ex post proceedings against EU members that would not comply with these fundamental principles. And as I said, our ELI principles or charter here has a nature of soft law, but given, of course, that Article 2 and 49 of the Treaty of the EU deals with these issues, there might be, of course, also ways to implement that, as we have heard also for the Council of Europe on the one hand, and here the European Union. And because we spoke a bit more on the Council of Europe, I thought, let's ask that. How do you see the implementation? Would a reform of Article 7 of the treaty be necessary in your eyes? And maybe I begin with Katarzyna, and then I go back to Elise so that she can either answer this question or wrap up with a final comment.
Thank you. I must say that I don't feel specialist in EU law in the sense of having on deciding on the responsibility of the states. And so if you don't mind, I will give the floor to,
Sure.
to Professor Muir.
Yeah, no problem. Thank you very much. Elise Muir.
Thank you very much. So what is the link with Article 2 and 49 of the TEU? There is no formal link, right, between this charter and in fact the EU legal order. I happen to be an EU lawyer, but the project, the charter for the ELI is meant to go beyond the EU, the specifics of the EU. So I think it's important to state that. That being said, of course, the values which are common to European liberal democracies matter from an EU perspective for the accession process and for the monitoring of the functioning of national constitutional democracies in the EU. How will EU key players, so the Commission or the Council, look into the charter? I'm not sure. It depends on how this charter is being used in the coming years. It clearly is soft law, as we have said. There is no... Now, if anyone wants to use it as a source of interpretation or to guide through any process, I think that the ELI, as much as we would be delighted. On the more specific question of should Article 7 TEU be modified, that's clearly a proposal on the table. The European Parliament has proposed a large-scale, has asked for a large-scale reform of the EU treaties in November, a few years ago, but it tabled a set of proposals in November 2023, on the 22nd of November. And among these proposals is a reform of Article 7 TEU for it to be more, less politicized and more powerful. Whether this will be accepted is, at the moment, in the short term, I think unlikely, but who knows? Let's see and watch. I think this is something to be watched, constitutional reform in the coming years. And perhaps if I may just speak on one final question that came into the chat, is there space to acknowledge obligations of individuals as a consequence of human dignity? I think it is true that the Charter only looks at rights. We, however, assert in several places across the Charter that the Charter is also intended to have as addressees non-state parties, including individuals. And for example, in the principle that I mentioned earlier, Principle 33, on the duty to uphold and respect constitutional values, we have specified in paragraph 3 that private parties have a duty to respect the Constitution and uphold the values and principles of liberal democracy. This is something on which we actually discussed a lot, this duty to uphold the values. So I think I just wanted to pick up on this question in the chat, because it's something that we hint at without being too firm, because I think being too firm would be too strong. But acknowledging that private parties have contribute to the functioning of liberal democracies matter, I think, really does. Thank you so much for your...
Thank you very much. That's a good ending, I think, also on this exchange of questions and also on the role of the various people. So maybe let me just conclude with a couple of final remarks. First of all, a couple of thanks, of course, to Professor Alice Muir for as representative, so to say, of the co-reporters in this project, for answering so clearly also the various aspects of the project and bringing forward also what the team, the assessors, but the two co-reporters and the two chairs had in mind. Thanking also the two other panelists that had to disappear very quickly at some point, because Patrick Charlier had to go here in Visage, but Director General Maria Huotanen had to leave very urgently, and so we are very thankful to both of them for their very interesting contributions, I have to say. And also thank you to you, Katarzyna Kozłowska, because I had to practice Polish with your last name. No, that's not the reason, of course, but thank you for bringing in also your very interesting thoughts on these issues. Now, of course, as I said, equality, and non-discrimination are fundamental rights that need to be improved and put forward and checked by various things. And that's why I think the discussion that we will have on the 6th of May on part 4 on checks and balances and accountability will be very important in that respect. And that's why, first of all, I thank everyone who attended this webinar today, and of course the panelists again, but also do not forget to join us for May 6th for part 4 discussion, where we will have also again very interesting and fundamental panelists discussing these issues of checks and balances in particular. So thank you very much. Enjoy the rest of your day, and I look forward to meeting you online again very soon. Thank you. Bye-bye.
Thank you.